My lord, here. This question objection or repeated, Purana Vita. Let us repeat.
May I please Lordship? Question of the adapter I beg to mention item number 8. My senior Akapuraka is not well. Kindly be possible for the day. Akapuraka is already submitted. Yeah. Respondent 2. Obligation.
May I please the Lordship, I am paying for listing of 2 criminal appeals, Lordship, arising out of same judgment. May I pay date, Lordship, kindly take up this matter 24th, Lordship. 24th, orders, Lordship. I is there. Obligation.
Lordship. In this matter, Lordship, your Lordship, call for one report regarding preservation of exhibits for matching of cement present in the victim's clothes and clothes worn by the accused person. Lordship, first order was 6-6.
It is there, your Lordship. It has come. The report has come. Lordship, can we have a look at the report?
Lordship, one report has come from the court below. Lordship.
Some exhibits has not been found, no? Zero
Yes.
exhibit has not been found. Then thereafter, but exhibit number so and so has not been found. But it has been
G is
G.
not able.
They-
G was also there, Lordship. G, Lordship.
G to together.
The page 127, Lordship. One airtight glass vial contains swab of accused person. Swab of accused person. Lordship.
Yes. Whatever is available.
Sees Lordship, navy blue colored skirt contains clean of suspected blood and semen. That is marked as C. Then D, Lordship. One light green colored small size panty contains suspected blood and semen. Lordship. Lordship, if it is preserved in proper condition, Lordship, that is written, Lordship. Still for so many years, Lordship, there may be some doubt, Lordship. 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 Lordship, that is written, but it might have dried up, Lordship. Whether the test result gives the correct.
Let them try.
Lordship. Yes, Lordship, that is true. Lordship may kindly make some observation in that regard.
No, sir. After investigation of the case by the investigating officer who found a prima facie case against the appellant under section 323/302/34 IPC. Charge sheet was submitted. No, sir. The learned trial court framed charges under section 302 IPC. Read with section 34 IPC. And section 323 IPC read with section 34 IPC against all the appellants. To which they all pleaded not guilty and claimed to be tried. Full stop. Next paragraph. The learned trial court thereafter examined 9 prosecution witnesses. And after examining the appellants under section 313 CRPC, came to a finding that the prosecution had been able to bring home the guilt of the appellants Satyen Das, alias Satyendra Narayan Das, and Balen Das, alias Bulen Das, B-U-L-E-N, under section 323 IPC, read with section 34 IPC. So, in respect of the appellants Manoj Das and Khargeshwar Das, the learned trial court came to a finding that they were guilty of the offense under section 302 IPC, slash, no, 302 slash 34 IPC and 323 slash 34 IPC. Just before this, Manoj Das and Khargeshwar Das, no? With regard to Satyen Das and Bulen Das, you just write. The learned trial court also came to a finding that the offense under section 302 IPC had not been proved against the above 2 appellants. Then next. Next paragraph. No, continue. Sub-paragraph. Subsequent to the conviction of the appellants in terms of the finding of the learned trial court, the appellants were sentenced as reflected in the foregoing paragraphs. Next paragraph. Being aggrieved by their conviction and sentence, the learned counsel for the appellants have prayed for setting aside the impugned judgment and order and sentence order. He submits that the evidence of the witnesses show that the assault made on the deceased had started with the cows of the appellant and the cows of the deceased fighting one another. It was due to the above issue that the appellants had suddenly, in the heat of the moment, assaulted the deceased. He submits that there was no premeditation to kill the deceased. And as such, the appellants should not have been convicted under section 302 IPC, but should have been what? Should have been convicted under section 304 or what? 304. 304 part 1, part 2, part 2 IPC. Anything else? Age. Okay.
Age, my lord.
But that's only with respect to Satyan Das.
Satyan Das and my lord, because of Julian Das also, my lord, his age is hardly 33 years back.
Okay, right. Mr. J. Roy also submits that the appellant Satyan Das is 82 years of age, while Manoj Das is 42 years. Mr. Khargeshwar Das is 38 years, while Balen Das is 33 years. He submits that keeping in view the ages of the appellants, some leniency should be shown to the appellants. That's all. Ms. B. Boyan, the additional PP, on the other hand, submits that PW 2, 3, and 4 are eyewitnesses to the appellants assaulting the deceased. She submits that in terms of the judgment of the Supreme Court, in the case of Dash versus Dash, 2023, 6 SCC 552.
They've brought the big business.
Prior meeting of minds / premeditation is not required to prove the charge of murder.
Common intention.
As there is a common, as the common intention to kill can arise during,
The spur of the moment.
can arise during the spur of the moment. Para
There are 15 now.
15, 1-5. But this is different. This is
No, your lordship, they have referred one,
Gurbachan Singh.
yes, Gurbachan Singh, and therein it has been stated.
Yes, stated what?
Uh,
Given the aforesaid, we are of the view that section 34
yes.
is clearly attracted.
yes. Common
Oh,
intention
no,
can be
no.
formed at the spur of the moment and during the occurrence itself.
Okay, next. Anything else?
Yes, it was on the vital part of the body.
Uh-huh.
Intensity was so,
Okay, right. She also submits that the blows that were inflicted upon the deceased shows that it was on the vital part of his body, that is the head. And the evidence shows that the brain of the deceased had come out, which showed the intensity of the blows inflicted upon the head of the deceased. As such, it cannot be said that there was no intention to kill the deceased. That's all.
the deceased was, is it about 37 years, your lordship, young.
Uh-huh.
They have taken the life. So your lordship has to balance both the sides. Think about the victim's family. They have lost the life of a young man after 37 years. So that factor, your lordship. take it.
She also submits that as the deceased was a 37-year-old person, this court would have to, this court should keep in view the fact that a family has lost a strong young man who could have helped the family. That's all. And anything else?
Exception may not be, benefit of exception may not be.
She also submits that section 304 part 2 is not attracted in the present case. So, Mr. So-and-so, the learned amicus curiae, submits that the evidence of PW 2, 3, and 4 prove that the appellants Manoj Das and Khargeshwar Das had intentionally killed the deceased, and that Satyan Das and Bulan Das had assaulted the deceased, they have not assaulted,
They have.
had assaulted the deceased. The deceased with
Oh,
a
lordship,
bamboo.
may I see? I
With
will
a
be wrong.
bamboo, yes, with a bamboo. As such, there being no infirmity with the decision of the learned trial court, the same should not be interfered with. That's all. We have heard the learned counsels for the parties. The evidence of PW1 who had examined PW3, that is the neighbor of the deceased, and who had also been assaulted by the appellants, is to the effect that there was pain and tenderness and swelling over the right shoulder joint and neck region. There was also tenderness over the left scapular region. This is page 11. Huh? Full stop. The nature of injuries was simple and caused by a blunt object. Full stop. Next part. PW2 who is the neighbor of the appellants. So the neighbor of the appellants and father of the deceased is to the effect that at about 5:30 p.m. about 3 years ago, while he was in the courtyard of his house, he saw a scuffle. He saw an altercation and scuffle between PW3 and the appellant Manoj Das over some cow related issue. The appellant Manoj Das was beating the cow of PW2 with a bamboo cane. He then saw the appellant Satyan Das assault PW3 with a bamboo stick, with a bamboo pole. The other appellant persons, the other three appellant persons also assaulted PW3. On raising a hue and cry, the deceased came out of the house and stood near him. As soon as the deceased stood near PW2, the appellant Khargeshwar brought a yoke from their cowshed and hit the head of the deceased with it. The deceased then sat down. In that situation, the appellant Manoj Das hit the head of Hitesh with a wooden baton. What is this baton? Baton, B-A-T-O-N.
ATM.
No, it cannot be B-A-T-E-N. What is a baton? B-A-T-E-N. Now, there's no word baton. I can understand a batter. If you see, baton is for relay. That's for relay thing. But there's no B-A-T-T-E-N.
Yoke, my love, I have seen in the
Let me see. Give me a dictionary.
yoke is a wooden.
No, yoke is
No, that
okay.
is
I'm talking
understood.
about the
Yes.
wooden baton. What is
Baton.
this wooden baton? I've never heard of.
Button is button. Button what is there, you know?
There's a B-A-T-O-N. That much I know. There's a batter. B-A-T-E-N for batting eggs, maybe.
Button meaning in English. Oh, button on trouser.
Pattern is a double T-E-N. Is there.
Huh?
double T-E-N.
B-A-T-T-E-N.
E-N.
Meaning
It's something like wood, my lord.
wooden button.
Wooden baton. Baton. Baton is,
B-A-T-T-E-N.
yes. Baton is a long flat strip of square timber or metal used to hold something in place or as a fastening against a wall. A strip of wood or metal. Okay, baton. Is square timber. Okay. So what have I said? With a wooden baton. So, due to which his head cracked and his brains came out.
Lordship, may I take the Lordship's leave?
Why?
Having a hearing with input number 6. May I?
Okay,
They'll be there.
let
Lordship.
someone be here. So, then next. Thereafter, his nephew Arun came and and drove away the appellants. As the deceased fell to the ground. They carried him into the house. Doctor came and gave him treatment. Gustav, later, while he was being taken to Dubri for treatment, he expired. In his cross-examination, PW1 states that, PW2 states that his plowman, bracket PW3, was bringing home the cows from the paddy field. When the cows reached, when the cows were near, when the cows of PW2 were near the cows of the appellants, their two cows got into a fight with the cows belonging to the appellants. Gustav. The cows Gustav. Then the appellant Manoj Das tried to drive the cows away by beating them. When PW3 questioned Manoj Das as to why he was beating their cows, a quarrel ensued. Thereafter, PW2 asked PW3 to bring the cows. And due to which, and as he was shouting, the deceased came. PW2 in his cross-examination also stated that the yoke was taken by the police. Next paragraph. The evidence of PW3 is to the effect that he knew the deceased while working as a domestic help in the house of the deceased about 3 years ago. He was bringing home the cows from the paddy field at around 5:30/6 p.m. While bringing home the cows, the two cows of the appellant got into a fight with the cows of PW2. When he tried to separate the cows, the appellant Manoj Das beat their cows with a bamboo. PW3 then told him not to beat the cows. When he started going with the cows, the appellant Khargeshwar Das grabbed him from behind, and the other appellants, namely Manoj Bulen and Satyan Das, caught him and started assaulting him with bamboos on his head, back, and legs. The deceased then came out of his house and tried to separate PW3 from the appellants. The appellants then pushed away PW3 and started assaulting the deceased. He saw he saw the deceased lying on the ground with bleeding injuries on his head and ears. In his cross-examination, PW3 says that he did not witness the deceased being assaulted. He also denied the suggestion that he did not sustain injury. Next paragraph. The evidence of PW4 is to the effect that he knows the appellant and the deceased. While he was at home on 15/5/2003 at 5:30 p.m., he heard the sound of quarrel. When he arrived at the place of occurrence, he saw the appellant Khargeshwar Das assaulting the deceased on his head with a yoke. He also saw the appellant Manoj Das assaulting Hitesh on his head with a baton, B-A-T-T-N. The appellants Satyan and Bulin Das also struck the deceased once or twice with split bamboo sticks, and they went home thereafter. PW4 states that he saw the deceased lying on the ground smeared with blood. He tried to stop the bleeding by pressing a gamosha hand over Assamese towel close on the head of the deceased. Villagers gathered there and they called a doctor. After giving first aid, the doctor referred the deceased to Dhubri. However, the deceased died on the way. In his examination in chief, PW4 denied the suggestion that Khargeshwar and Manoj Das had not hit the head of the deceased with a yoke and baton, B-A-T-T. He also denied the suggestion that he did not see and he did not state before the police that Satyan and Bulin Das have struck the deceased once or twice with a bamboo stick. Next paragraph. The evidence of PW5 is to the effect that he knew the appellants and the deceased. Around 5:30 p.m. one day, about 3 years ago, he heard a hue and cry in the house of the deceased, and on rushing there, he found the deceased lying injured on the ground and his mother was holding him. Ustad. On arriving at the place of occurrence, PW 5 stated that he saw the appellants Manoj Das, Khargeshwar Das, Satyen Das, and Bulin Das going out from the compound of the appellant's house. This is house of the deceased. Ustad. He came to learn from PW2 that the appellants had assaulted the deceased. Next para. The evidence of PW6 is to the effect that he knew the appellants and the deceased. Around 5:30 p.m. on 15/5/2003, he heard a hue and cry in the house of the deceased. On rushing there, he saw the deceased with injury on with bleeding injury on his head. On his arrival at the place of occurrence, he saw the appellants Manoj Das, Khargeshwar Das, Bulen Das, and Satyen Das going out from the house of the deceased. Next para. So it's quite apparent that everyone's seen. Only thing is whether we can listen it or we'll have to see. The evidence of PW7 is to the effect that he knew the appellant and the deceased. He knew the appellant, she knew the appellant. So further, the deceased was her husband. After visiting a temple and coming home, she saw her husband lying injured in the inner courtyard of their house. She thereafter came to learn from PW4 that Khargeshwar Das and Manoj Das had assaulted her husband with a yoke and baton, respectively. Next paragraph. The evidence of PW8, who is the doctor posted at Dobri Civil Hospital as senior medical and health officer, is to the effect that he conducted autopsy over the dead body of the deceased on 16/5/2003. And he found the following injuries. At page 28, from here to here, in blue. Then PW8, first up, PW8 in his subpara, in his evidence, stated that in his opinion, death was caused due to shock and hemorrhage resulting from head injuries sustained by the deceased, and all the injuries were ante-mortem in nature. Next, PW9, who was the duty and in charge of Raniganj police outpost, stated that on 16/5/2003, PW7. Lodged FIR, due to which a GD entry was made. Pusta. Thereafter, Bilasipara Police Station case number was registered. And thereafter, a police case was registered in the Bilasipara Police Station. Pusta. On taking charge of the investigation, he visited the place of occurrence and examined the witnesses. He also seized the yoke. Pusta. During investigation, he prepared a sketch map of the place of occurrence and prepared an inquest report. Pusta. After the inquest, the dead body was sent for post-mortem examination. The appellants were arrested and on completion of the investigation, charge sheet was submitted against the appellants under section 323/302/34 IPC. In his cross-examination, PW9 denied the suggestion that he had submitted the charge sheet without conducting proper investigation, or that the witnesses did not tell him that the accused persons has caused injury to the deceased by assaulting him. Yes, sir. Next paragraph. Subsequent to the testimony of the prosecution witnesses recorded by the learned trial court, the learned trial court examined the appellants under section 313 CRPC. Yes, sir. The appellants, in their examination under section 313 CRPC, gave a blanket denial with regard to the questions put to them by stating that the evidence were false evidence. The evidence adduced were false evidence. Okay, hearing concluded, judgment reserved.
Only thing is that on the PW,
Huh?
PWD3, who is also being assaulted, he didn't say about baton or yaw.
Correct.
He said stick. And second thing, he did not see
But 2 and 4 are there.
Hitesh being assaulted also. So he's up in the side, but he didn't saw Hitesh.
Correct, correct. She did not say
Yes.
because he was injured. He was the one who was injured. PW3 is the neighbor who was injured. He's that Mendrai or
Right.
Menra.
Brought up.
Mendrai. But then the 2 and 3 are 2 and 4 are stated. 2 and 4 is proven. Only problem you see, one thing is that the force with which they've been hit. Imagine brains
Brain
scattering.
material is
Yes, it's quite
Brain matter only the wife had said that. and nobody else.
You have not put a suggestion to them that is false. You have not said that is false. One is enough. One witness is enough. Anyway, let us see. We have got any other matter? Huh?